and welcome everybody to our procurement update, which is part of our higher education webinar series. I'm Stephanie Rickard, and I head up the procurement and subsidy control team at BWV. And it's a very exciting time in procurement and subsidy control at the moment. So on the next slide, please, I've set out the topics for today. I'm going to cover two recent procurement policy notes, look at some procurement cases which have practical application to running tenders, and discuss the latest thinking on the government transforming public procurement reforms. I anticipate that the sort of the formal part of the presentation, if you like, will last about 30 to 40 minutes, and there'll be plenty of time afterwards to answer any questions that you may have. So before I start, I just wanted to run a quick poll. Thank you. I was hoping at the time I presented this webinar that the Procurement Bill would have been published. I'm going to return to the Procurement Bill later on, but to kick off with, I'm very interested in your predictions as to when you think the Procurement Bill might actually come into force. So if you can choose one of the options on the poll. Right, that's interesting. So majority for October 2023, with 13% saying June 2023 and 38% saying sometime in 2024. Well, I've written my prediction already on my slides, and I'll give that to you later. Thank you for that. So the first procurement policy I want to talk about is PPN 122, dealing with contracts with suppliers from Russia and Belarus. We've been receiving a lot of queries about how clients can respond to the Ukraine crisis. And we're delighted actually that we'll be welcoming a Ukrainian lawyer to our commercial department very shortly. The purpose of the PPN is to give guidance to contracting authorities on their rights and responsibilities under procurement law to respond to the situation. And whilst the guidance is not mandatory for HEIs, nevertheless, you should have regard to it in dealing with existing contracts and also in new procurements. Now, there are a number of recommendations that are set out in the PPN. The first one is to review your existing contracts and supply chain to identify if any of your suppliers are based in Russia or Belarus, or whether they're controlled by a Russian or Belarus organization. Now, it may be the case that you will have lots of framework agreements that you're party to, and it may be that actually you want to raise a number of questions with the framework provider to understand whether that is an existing contract. Now, if you find that you have got contracts with Russian or Belarus suppliers, then you might want to consider if the contract provides a right to terminate, and if in fact termination is appropriate. In practice, the types of contracts that are most likely to identify suppliers from these areas are for energy supply or raw materials, or possibly we had one instance of components for particular research purposes. Now, the situation with new procurements is that you may be able to exclude suppliers from Russia and Belarus from new procurements. There are a couple of points that are worth noting: that Russia and Belarus are not members of the WTO government procurement agreement, so there are no provisions about non-discrimination of suppliers that will trigger under those agreements. But you need to check very carefully that suppliers are not based in the UK or have substantial operations, as they might fall within the scope of the PCR, and then the non-discriminatory considerations are relevant. I know that there may be one or two attendees from local government procurement teams who are attending this webinar. It's important to note that the PPN 122 is not applicable to local government because the Local Government Act precludes non-commercial considerations. So I just thought it was worth making that point here. So the next PPN that I want to consider is 921, publication of contracts finder, on the next slide. Now, we've received a number of queries on the application of 921 from education clients, and on the face of it, it should be relatively straightforward, because what the PPN is doing is simply clarifying that the contract finder thresholds now include VAT. But in practice, I think it's rather confusing, because it needs to be read alongside the updated guidance note on transparency. There are a number of changes that appear to have been made to that guidance note, which I think are just worth focusing on. So the fact that the 25,000 threshold for wider public bodies to publish information on contracts finder now includes VAT means that in practice a wider number of procurements are going to be caught. Now, the rules on transparency relate to advertising contract opportunities on contract finder, but I really just wanted to focus on the rules about publishing certain contract award information. Now, the information requirements as a minimum are that the requirement to publish extends to the name of the successful bidder, the value, whether or not that bidder is a SME or voluntary or community enterprise organization, and the date of the award. But it also, it's circumstances when you need to publish for a contract award that I just wanted to bring attention to. Next slide, please. If we can move on to the next slide. That's lovely, thank you. So the requirement to publish contract awards clearly applies to competitively tendered contract awards, but it also applies to individual call-off contracts under frameworks, and the guidance notes talks about the fact that it also applies to awards that have not been openly competed. For example, where quotations have been sought or a decision has been made to go down the single tender route. But to my mind, this means that the university may have made a decision actually to take the risk of a particular course of action, but under the rules it's still saying you need to issue a contract award. Now, the rules on modification, again, are slightly confusing. They seem to suggest that if you're making a modification and it's covered by some of the grounds for permitted modifications under Regulation 17, which governs substantial modifications, then you don't have to publish a contract award notice. But if there are other grounds which fall outside 72, then you do have to cover a contract award notice. So I think in terms of practical points is when you're considering your procurement options and strategy and routes, you probably need to think about the risk analysis also to include whether or not you have to publish a notice under Contracts Finder. So I'm now going to move on to talk about some of the recent case law. And the themes arising out of recent case law, there haven't been any really big cases, but there have been a number of interesting cases which all seem to focus on the application of the principles of fairness, transparency, and non-discrimination. Now, many of you will have been aware of the challenges brought by the Good Law Project in relation to government contracts awarded during the pandemic. There have been a total of 3 challenges. The first one arose in relation to the failure of Michael Gozen Department to issue contract award notices contrary to government guidance. The second one related to the use of VIP lanes for PPE procurement. And the court decided there that the use of a VIP lane was contrary to the principles of fairness and transparency, because those suppliers who were referred to that lane, actually their bids were evaluated first and they were more likely to be awarded the tenders. The third case that I'm going to talk about is about apparent bias. Now, all the challenges brought by the Good Law Project were brought by way of judicial review. The facts of the apparent bias case related to the appointment of political consultancy to provide urgent focus group testing. And some of you may recall that the allegation was that the firm has close links to Dominic Cummings. Now, at first instance, the judge found that there was no apparent bias, but criticised the failure of the Cabinet Office to keep a clear record of the decision to use the chosen consultancy. And one of the things that was relevant was that this was a consultancy which had no existing contracts with the government, but there were other political consultancies which did have existing contracts, but nevertheless weren't awarded the contract. Now, the issue at first instance came down to the fact that there wasn't a clearly, well, it was alleged that there wasn't a clear document trail setting out the reasons for the appointment of the political consultancy. But and therefore, it was found that the decision that the Cabinet Office had made to award the contract was a wrong decision. However, in January of this year, that decision was overturned at the Court of Appeal, and it was found on the evidence that actually a fair-minded and informed observer, which is the test for an apparent bias case, was that they wouldn't have concluded that there was bias in this particular case, and because the award was held to satisfy the conditions for extreme urgency, there wasn't a requirement for a detailed note setting out justifications for the decision and looking at alternative supplies. So it may be that the case is particular to its facts, but I think there are a number of comments that one can make in relation to the case that are worth bearing in mind. Firstly, it's an interesting case because it talks about apparent bias, and it's always much better to make sure that bias doesn't arise in the first place, because it's pretty difficult to unwind if there is an allegation. So that highlights the importance of making sure that conflict of interest forms are assigned at the appropriate places in tender processes. Now, in this particular case, there was never any evaluation because there was just involved, which is where apparent bias often comes up, because the contract was just awarded. It emphasizes the need for making clear audit trails regarding decision-making processes to avoid challenge. But interesting, there's also some discussion about the use of judicial review. None of the, there were no complaints from suppliers about the form of award, and the courts said that they were reluctant actually to use judicial review where in a procurement case, and that may be something that is followed through. The second case that I want to talk about is about framework agreements, and this is a Danish case of Simonsen and Veal. So in this particular case, the facts concerned a single supplier framework agreement, and there was a complaint by an unsuccessful supplier that the framework agreement wasn't valid because the tender documents didn't contain an estimate of the value of goods to be procured under the contract, or state the maximum quantity to be procured. Now, there was some information in the later procurement documents, but it wasn't clear on the face of the contract notice. Now, in practice, I understand the difficulty of trying to estimate the value of quantities to be procured under a framework agreement, because very often you don't know in advance how much you're going to procure, but particularly actually if a framework agreement has been set up with multiple users. But the European Court of Justice held that there is a requirement to indicate the estimated value, and more importantly, the maximum value or quantity of supplies to be procured under a framework, even actually if this is a high figure. And there is a risk if the values are not properly identified, that it may result in called-off contracts or frameworks not being eligible. Now, although this is an ECJ decision, it follows a line of cases which have been making similar points. It's unclear whether it would in fact be followed in the UK courts, but I think the practical guidance is this, which is that if you are a framework operator, you need to try and provide a maximum value, at least for the goods or services to be procured under the framework, and must try and make a reasonable attempt if there are other contracting authorities to try and provide an estimate for usage. If you're a framework operator, it's important to keep a record of that usage. And if you are a university who wants to call off under a contract, then it is worth checking that the proposed value is still within the maximum limits. And on a couple of frameworks when I've been advising on recently, that's certainly something that I've been advising clients to do. Okay, so the third case is a Welsh case involving the procurement for mental health services. Now, this case was sub-threshold, so there wasn't a requirement to carry out a regulated tender. And the complainant, what they sought to do was to bring a challenge under the procurement rules for breach of the general EU principles of fairness, transparency and non-discrimination. Now, this case was heard after the UK had left the EU, and the court held that because the case was sub-threshold and didn't involve any cross-border interest, that the application of the general EU principles didn't apply, and therefore there was no cause of action that could be brought. So I think that's an interesting case. I thought it would be helpful to make some more general comments about procurement challenges based on our experience in the last couple of years. If you could move on to the next slide, please. I think certainly that we are seeing much more attempts from suppliers to bring into pay issues or complaints about fairness, transparency and non-discrimination. Because if you can demonstrate that there are issues with the principles, the judges are much more likely to take a more detailed scrutiny of particular complaints, and it's also a ground for opening up evaluation criteria. We're seeing quite a lot of challenges or potential challenges in the IT sector for education clients, particularly around HR and payroll systems, and about sort of database systems. I think that's because there's a number of quite aggressive suppliers about. We've talked about greater use of JR, and whether or not that will be a thing will be interesting because of the government's intention to increasingly rely upon guidance through PPNs rather than sort of the more traditional legislation routes. So going on to my third topic, returning now to the sort of long-awaited Procurement Bill. So as many of you will be aware, the government published their response to the Transforming Public Procurement consultation in December last year. This has actually been the latest substantive update. There have been a couple of updates by email from Cabinet Office about the learning and development proposals, but very little on sort of the timing or any more sort of substantive developments. But I thought it would be useful to highlight some of the areas where government thinking has moved on. So the government has signalled its intention to proceed with the consolidation of the regulation so that the regulations will include the rules relating to concessions, and the utilities rules will also be incorporated into the same legislation. Now, originally, the government had intended to remove the light touch regime, which obviously applies to education services, on the basis that the new procedures would all be more flexible. But I gather that this is under review because the government recognises that in some cases the light touch regime offers, obviously it has a high thresholds that apply more flexible time limits and procedures. The government have promised that the consolidated procurement bill will be clearer and simpler to understand. So I think what this means, and we've seen some examples from the subsidy bill, is that there'll be a tweaking of language, probably for political purposes, but actually the concepts will remain the same. So we're going to have to get used to new language. So one of the examples is that the contract notice, which is the start of a procurement process, properly will now be replaced by an appropriate tender notice. One of the areas where government have set out their thinking in a lot more detail is exclusions, and I'm going to pick that up in a minute on the next slide. When I gave my webinar last year on the Green Paper reforms, I spoke about resourcing and privacy concerns around the proposed transparency requirements and use of the open contracting standard. Now, I know that the HE sector has lobbied Cabinet Office quite hard on this point and obtained a concession so that the increased transparency requirements only apply to contracts in excess of 2 million. So I hope that will be helpful and reduce some of the administrative burden. There's also been a lot of feedback on the proposed changes to remedies, but they're now going to be largely retained. There are some changes to the standstill period, which I'll come on to. So on the next slide, I've set out some of the changes in relation to the new exclusionary regime. There were comments that that needed to be more certain and clear. So it's proposed that there are new mandatory grounds for exclusion introduced, which include modern slavery offences, if a company is found to persistently fail to pay minimum wages. I'm thinking particularly of the sort of P&O issues that have been talked about a lot in the press recently. At the moment, breach of competition law is a discretionary offence, but they're going to split competition law into 2 grounds. So the most serious competition law breaches, as determined by the CMA, will be grounds for mandatory exclusion, with less serious grounds still being grounds for discretionary exclusion. There have been a lot of comments about the fact that it's very difficult to exclude suppliers based on poor performance because the grounds for exclusion are very narrow and only relate to where a contract has been terminated as a result of poor performance. And from experience, I know that in practice, very often a sort of there might be a sort of settlement reached rather than terminating for poor performance. So there will be a rider ground for poor performance if, for example, issues have been brought to the attention of supplier and a remedial plan has been put in place, but then that fails. There's also a discretionary ground for obtaining confidential information that affects the fairness of a procurement. Now, I've been involved in a case recently where the government inadvertently released a copy of a contract to a bidder in circumstances where it shouldn't have done. And we argued that that affected the fairness of the procurement process. So that is going to be a new discretionary ground. In terms of time periods, contracting authorities will be able to go about 5 years to identify circumstances that have occurred. There's also going to be a central disbarment register to help with verification regarding DD on these points. So standstill letters, it was one of the things that I felt quite strongly about from the proposed reforms. We'll go on to the next slide, please. That the original proposal was that a lot of, instead of writing debrief letters or standstill letters to bidders, that everything would be published in an award notice. And I had concerns about privacy and confidentiality issues. But the government are proposing a compromise position, whereas award notice will be published setting out the outcome of the procurement and identifying all the bidders, but that unsuccessful bidders would be provided with the redacted evaluation documents for the winning bidder, but they would also be provided with their own individual evaluation documents in an unredacted form. And in practice, actually, what we're seeing is that if there is very often a challenge, then the next step is to ask for all the evaluation documents. So this is really cutting out, I suppose, actually a lot of the work in preparing the standstill letters. I can see there's an advantage of that. And so it'll be really important to make sure that the evaluation documents are set out in a clear manner and set out how the decision-making process has been made. So where are we now then in terms of the public procurement reform? Next slide, please. So it's the procurement bill was hoped to be introduced in this year's parliamentary session, but it hasn't yet been appeared. And my thought is that it's going to be rolled over to the next Queen's speech, which I gather is scheduled for the 10th of May. The government have said that there will be a minimum 6-month go live transition period to allow for the necessary training, learning and development, and also for the publication of guidance on interpretation that will be required. So in terms of my prediction, I share actually the majority of your thoughts that it's going to be later in 2023. I actually cheated and wrote down on my notes that it would be December 2023, which I know isn't one of the options that I gave to you. But I'm very conscious that I got my predictions wrong last year. I was thinking that the procurement bill would more or less be in place now, but events have overtaken, I think, the importance of the procurement bill. So in terms of final thoughts and what it means for the HE sector on my final slide, I think there definitely is a push towards much greater transparency in the decision-making process, which in turn is going to really test the ability of universities and other contracting authorities to carry out a detailed audit trail, setting out the thinking behind all the decisions, so that if there is a query, positions can be justified. So I'm very happy now to take any questions, and I'm just going to go and have a look to see if there are any questions. If you want to send across any questions, do ping them across in the question and answer box. Oh, it looks like I'm going to get away lightly. Oh, I think there might be a question. Right, there's a comment that's been posted. Right, I think this is a comment. So in relation to the Aneurin Bevan University case, was the source of funding for the purchase from funders who stipulated that the EU regulations should be followed? Interesting that even in such circumstances, there's no obligation for a UK-based university to apply the principles of EU law when procuring. I think that's a very interesting point. I'm not aware that there was grant funding that required EU regulations, but the decision clearly is a change from the previous situation where, I mean, there was clear case law. I think there was a PhotoMe case against Network Rail a while ago, which related to a concession contract, and that was very clear that sub-threshold contracts were capable or should have the principles of fairness, transparency, and discrimination applied. And obviously, the Aneurin Bevan case seems to change that.